Every day in the USA, people find themselves in court.
We now call 20-33883, the state of Texas versus Richard Lee Anderson. You are Mr. Anderson,
Yes.
the defendant in this case, and you were present with your attorney, Mr. Smith, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
And this is a trial that we have been moving forward on since Monday, and the parties have reached an agreement to dispose of this case outside a jury verdict. And again, the defendant waives a formal reading of this indictment. We're only going on paragraph 1.
That's correct.
And also arraignment is waived as well.
Yes, Your Honor.
In summary, Mr. Anderson, this indictment alleges that on or about October 2nd, 2018, in Jefferson County, Texas, you committed the first-degree felony of aggravated sexual assault of a child younger than 14 years of age. Do you understand what you were charged with? You have to speak out so she can hear you, sir. Thank you.
Sir.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range that is applicable for a first-degree felon?
Yes, sir.
An agreement's been reached between the parties. You would be pleading guilty and found.
No contest.
I'm sorry. Stand by. All right, you would be pleading no contest. There would be an opportunity for the state to present supplemental information into the record to support your plea of no contest. But if there is evidence supporting a no contest plea, that can be enough to find you guilty beyond a reasonable doubt of this offense. Do you understand?
Can you say that one more time, please?
Pleading no contest does not absolve you of being responsible and found guilty. Do you understand? It is up to the state to then present evidence. You don't have to plead guilty. You can plead no contest. But then it's up to them to present additional evidence to support your plea of no contest. And it's their obligation to meet the threshold for the court to find you guilty beyond a reasonable doubt. Do you understand? The plea of no contest does it is not a plea of guilty, but it is an understanding that you are being neutral on this. You are withdrawing your plea of not guilty, and we are moving forward based upon an agreement that's been reached by the parties. And that's the way it moves in this court. Sometimes people plead no contest. The state still has the obligation to present evidence. Here, generally, you've signed a document in this agreement that states that you were giving up, you were mentally competent to enter your plea of no contest, which is freely and voluntarily made. You were totally satisfied with the representation provided by your lawyer. You were giving up your rights to a jury trial and the right to the appearance, confrontation, and cross-examination of witnesses. And you are giving up your right to a pre-sentence report, and you swear all of this is true, so help you God. Is that so?
Yes, sir.
All right. An agreement's been reached where you would be sentenced to 10 years in prison. 20-33885 case would be dismissed. You would be given credit for all time you have served, and that is the law. Is that your understanding of the agreement?
Yes, sir.
And then the state would not be prosecuting you for paragraphs 2 and 3, which would, if found true beyond a reasonable doubt, which would subject you to being habitual offender status, and then the punishment range would be no less than 25 to life in prison. Do you understand?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
State of Texas, you have an opportunity to supplement the record on a no contest plea with evidence.
State would tender all of the exhibits and testimony that was admitted during the trial, and state would tender State's Exhibit 9, which is the sexual assault examination and forensic report form, to the court.
No objection.
Without objection, all of that is admitted. All right, is there anything else to add? I'm going to make my findings. I'm going to find, Mr. Anderson, you have pleaded no contest today voluntarily, knowingly, intelligently. There is enough evidence from State's Exhibit 1, along with the evidence that has been admitted into this hearing without objection by the defense to support your plea of no contest, to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of aggravated sexual assault of a child. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. And again, you will be given credit for all time you have served in conjunction and connection with this charge. Now, there is sex offender registration.
It's been sent to you, Judge, on the
And
tablet.
I'm going to show you here what is called Sex Offender Registration Admonishments, Chapter 62, Texas Code of Criminal Procedure. Mr. Anderson, did you sign that document? Discuss it with your attorney? Are the contents all true and correct?
So, yes, sir.
Okay, thank you. All right, this item is presented, made a part of the record for all purposes. And it states that you understand you have a reportable conviction or adjudication, or you are otherwise required to register in the sex offender registration program because you have been found guilty under section 22.021 of the Texas Code, Texas Penal Code of aggravated sexual assault involving a child younger than 14 years of age. You now have a reportable conviction. You must comply with Chapter 62 of the Texas Code of Criminal Procedure, Sex Offender Registration. Failure to do so would be a criminal offense that can result in prosecution. If you move to another state that has similar reporting requirements for sex offenders, you must register in that state. Failing to register can result with you being charged with a criminal offense. Do you understand your obligations that you have here, sir?
Yes, sir.
All right. That is made a part of the record for all purposes. Finally, 20-33885 is before the court. There is a motion to dismiss that without objection. That case is hereby dismissed. Do you understand what has happened today, sir?
Yes, sir.
All right. Anything else by the parties that
No,
needs?
None from the state.
Okay, we're not going to have any other proceedings
No, Your Honor.
that sometimes occur in this type of matter. Okay. Then anything else to add from the defense?
No.
All right, then the defendant is taken into custody. What will happen is we'll bring the jury in, tell them what has occurred and release them. All right,
Thank
thank you.